Hello and welcome to Business Law. This week one, we're just going to kind of get started talking about the basics. First of all, basically, what is the law? Why do we have it? What does it do? Where did it come from? So we're going to do that, look at those basic questions, and then also kind of take a look at how we think about the law. You'll be reading a lot of different cases and just kind of give you some tools on how you would analyze those and kind of get some meaning from that. So let's just start off talking about what the law is and what it does. Really, you can define the law as a set of rules that a government requires its citizens to follow. These rules can do a number of different things. It can force you to do something. For example, it can force you to pay your taxes, to do something you wouldn't otherwise necessarily want to do. It may force you to not do something. It can keep you from beating up your neighbor, it can keep you from trespassing on your neighbor's lawn, stealing your neighbor's stuff, things like that. The law comes from many different sources. We'll examine that soon. There are things like constitutions, statutes, court decisions, even administrative regulations. But all of them have something in common. That is, they are legally binding. That is, the government can punish you if you break the rules. And it doesn't matter if you're an individual, a corporation, some other kind of entity. If you're within the geographic area government controls, like the state of Missouri or the United States of America, the government there can punish you if you don't follow the rules. So the law is legally binding. That's what we say. Well, the most basic purpose, why do we have these rules, is to create an environment that allows civilization to function and prevent anarchy. If you ever wondered what the world would be like if we didn't have law, just consider what New Orleans was like in 2005 after Hurricane Katrina struck. Basically, there was no order anymore. Legal authority had broken down. People were just trying to survive. And so you saw all kinds of things going on. There was some looting, there was crime, there was all kinds of chaos. People just trying to survive. We saw that in Iraq after the invasion in 2003 and the years following. Government authority had broken down. There were all kinds of militias running around with guns. Basically, it was just chaos. And that's the kind of thing that we see if we don't have law. So law exists to prevent that kind of chaos and anarchy. So we like our freedom, but we have to have some kind of limits on that to provide an established framework everyone can live by. And what law does by preventing that chaos, it gives us predictability and certainty. And that's really important because you can plan for the future if you have those things. Let's just take an example. Let's say that you're living in Iraq during the worst time of it when there really was no government. Are you going to take out a 30-year mortgage on a house in an environment like that where you don't know, is your neighborhood going to get burned down the next day? Are you going to get shot? Is your ethnic minority going to get wiped out? You really have no idea what's going on. And so in an environment like that, you're not going to make that kind of long-term investment. And that's true of businesses as well. You're not going to build a factory in that kind of environment and hire a bunch of people to make widgets if you're worried about somebody coming in and murdering you or stealing all of your stuff or burning your building down or that kind of thing. And so it really puts the brakes on the economy if you don't have predictability and certainty, because people won't make investments. And certainly, it hurts on a personal level too. You need to be able to live your life in a predictable way. And so the law provides that kind of environment that civilized society requires in order to function. We do have to realize, though, that freedom and order are polar opposites. And what I mean by that is, we have freedom. We cherish freedom in this country. We can say what we want for the most part. We can believe what we want. We can, hold the kind of job that we want to do. We can, do a bunch of different things, and we value that freedom. However, if you take that to its extreme, in those chaotic environments we were looking at where there is no law, they have total freedom. They can do whatever they want. They can go shoot all their neighbors if they want to. And that's the kind of freedom we don't want. We need a break on that, and that is order. And law provides order. However, while we need some order, we can have too much. And if you want to see the other extreme, look at North Korea. In North Korea, you can't say what you want. You can't believe what you want unless it's agrees with the government at least. You can't necessarily have the job that you want. You can't live in the place that you want. They have lots and lots of order. So they don't have much chaos. They have complete predictability and certainty, just about. You know what to expect, but there's no freedom. And so we don't like that other extreme either. So one job of government is to kind of strike a balance between freedom and order. And they are really opposites. The more rules that we have, the less freedom that we have. The more freedom that we have, the less order, predictability, and certainty we have. So somewhere in there, we have to come down in the middle and find out, the balance that will give us the freedom, the maximum amount of freedom, but also give us the kind of predictability and certainty that we need. So, also, the law is constantly changing. Society continues to evolve, and the law changes with that. Hundreds of years ago, they hung horse thieves. Well, now we don't have capital punishment except, for murder. So things change, society changes and evolves. Law has to change with that, otherwise it'll become obsolete and be unable to fulfill its functions. So that's one thing that's kind of frustrating about the law in a way. It keeps growing and changing. We can't, just say, oh, I know what the law is, and never read another law book, because it doesn't work that way. Every day, courts are handing down new decisions, new statutes are being created, all kinds of stuff, new agency regulations. When you go to law school, they give you, a basic overview of the law, but a lot of your education is learning how to find out what the law is, because we don't know what the law is unless we research it, because it's always changing. And so that's one thing to understand, as we go through a study of the law, is that these rules can change. They're constantly changing. That's why, hopefully your tax accountant, gets an update every year, because the tax law is always changing. So all laws are like that. So part of our job as students of the law is to understand how to find out what the law is, and to understand that it's constantly changing. Let's talk now about our legal heritage, and by that I mean where our sources of law really come from. We really have two major sources. One is the Roman civil law. The Romans really like to write down everything, and just kind of a book of rules, basically, that you would be able to read through and say, okay, this is what a good Roman does and doesn't do. Just kind of spelled it out there for you. That's the ancestor of our modern statutes, which we'll look at in more detail in just a second. We also have the English common law, which is decisional law. And again, we'll talk about that more in a second. First, let's look at what a statute really is. And a statute, and here's just a random statute from the state of Missouri, a statute really just lays out the rules. This is what you're not supposed to do in this case, and that is promote prostitution. And I just kind of chose this at random. This statute makes pimping illegal, pretty much. So if we read this statute, it has a title, promoting prostitution in the first degree. It says a person commits the crime of promoting prostitution if number one or number two, and then it defines a term that's used in the statute. The section that we just preceding this defines what the term compelling means, so there's no question about that. And then section 3 there says, by the way, this is a Class B felony, so if you're found guilty, you know how many years in prison you have to spend. Statutes are like this. They just really lay out what it is, what the consequences are. Really not too many unanswered questions there. And that's kind of what a statute looks like. So we just looked at statutes, and they really just spell out what the law is, what people should and shouldn't be doing, what the consequences of violating that may be. Just kind of, spells it out black and white. Well, it would be really simple if that's all we had, but we also have something called the common law. The common law developed in England over hundreds of years, and it's a body of decisions made by courts. What would happen is you would have a couple of folks maybe get into a dispute. One would sue the other. They'd end up in front of a judge. The court would hear both sides of the argument, everyone's reasoning, and then the court would make a decision, issue a judgment, and write an opinion explaining what was going on in the case, the decision the court made, and why that decision was reached. That was valuable because we could, if we had the same type of problem come up, say 10 years later, we could go back and look at what the earlier decision was that the court had made in a very similar case, and that would give us guidance in what to do the next time around. And that's really helpful because lawyers and judges really are kind of lazy in a way, don't want to reinvent the wheel, and so we wouldn't want to go, relitigate the same stuff from scratch every single time it came up if we could go back and see how a court had done it before. And that really makes the courts in a way more efficient. Also, we don't want inconsistent decisions. We don't want a court in Newton County to decide a case one way and a court in Jasper County to decide it the opposite way. We really want consistency throughout the law, and because that gives us that predictability and certainty. So when we have courts that are respecting each other's decisions, then that gives us that predictability and certainty. And so there was a doctrine developed called stare decisis, which is Latin for let the decision stand. This means that courts will give respect to decisions of earlier courts. So if a court decides, in 1950 that the sky is blue, and then someone comes along in 2000 and says, well, the sky is really green, a court's not really going to like that. They'll want to go with what the earlier court said. And so that's kind of a silly example, and I'll give you some more silly examples, but that's how stare decisis works, is that a court will hear a case, and then, that court will say, okay, well, has any other case been decided that, is similar to this case? And so what you have happen is a situation, let's say that you had a case where somebody was arguing that tomatoes are a vegetable and the other person was arguing that tomatoes are a fruit. And that got before a judge, and the judge said, okay, well, I don't know about this, but let's go and see if there are any other cases that have talked about this. And so the judge goes back and finds a similar case where this was already litigated once before, and the court decided that in fact tomatoes are a fruit. And so the court will come back and say, okay, well, this isn't a new question. A different court has already decided that tomatoes are a fruit, and I'm going to go with that. I'm going to respect that precedent. And so that's the principle of stare decisis. And it goes a little bit further than that, too. It even works in situations where our case isn't exactly like the old case, but similar. For instance, let's say that we have another case that comes up, and someone is arguing that peaches are a vegetable, not a fruit. Okay, so the court gets that case, and it can go back and find that tomato case. And, we're not talking about tomatoes here, we're talking about peaches. But the judge might look at that old case and say, okay, well, that court decided that tomatoes are in fact a fruit because they are round, juicy, and sweet tasting. Well, those facts are kind of similar here because tomatoes are also round, juicy, and sweet tasting. So the court can say, aha, I have this precedent, so I can use that to guide my decision today, and I'm going to build on what that earlier court did and decide that in fact peaches are a fruit, just like tomatoes. So that's a stupid example, I realize that. But that's how it works in real life, too. Consider what happened in the Civil Rights Movement. You may have heard of Brown versus Board of Education, which outlawed segregation of the races in public K through 12 schools. Okay, well, we had that decision made. That was a precedent. Well, folks were able to take that precedent and then apply that to public universities and say, well, discrimination is wrong there, too. And then take that principle and apply it to public buildings and say, well, we shouldn't have separate water fountains in the courthouse or something like that. And so we can take prior decisions and build upon that. And because we respect those earlier precedents, the law is able to develop in a fairly logical and predictable way. Sometimes a precedent isn't followed. And sometimes a court will just think, oh, that old court really screwed it up. Or things have changed in the 100 years that have passed since that decision was made, or that kind of thing. Or sometimes a court in Missouri will really respect the precedents of Missouri courts, but might not really respect the precedent of a Kansas court. That's a different jurisdiction, and just kind of say, okay, well, and it might be persuaded by that Kansas decision, it might not be. But, in general terms, once we've decided it a certain way, we kind of want to stick with that decision. It gives us that predictability and certainty. Well, you can kind of see that the English court system wasn't really designed, it just kind of grew. And because there was really no overarching plan, there were some gaps in the system. One of those gaps was that English courts they only were able to do one thing, and that was to award money damages. So, if you were suing your neighbor, they could give you an award of money. They couldn't make your neighbor do anything else except give you money. So sometimes that was helpful and sometimes it wasn't. So let's say that your neighbor, is making a big racket so you can't sleep, is banging garbage cans lids together or something. The court was able to, in that situation, say, okay, the bad neighbor that's banging your garbage cans has to pay you, $100. Okay, well, that's great, but there's nothing to stop him from banging the garbage cans together again. You really need is an injunction, some kind of order to stop him from doing it. But courts weren't able to do that under the English system. The only way you could do that was to go to the king. And the king could order people around, and sometimes the king would hear those kinds of cases. But over time, the king got tired of hearing all these cases, and so he developed a second system of courts. And those were courts of equity, or the chancery courts. And those courts had the ability to actually issue injunctions, tell people to stop doing something or to do something, whatever the case might be. And so courts today in almost every jurisdiction have both of those powers. If you go to court in Newton County, Missouri, and sue your neighbor, that court has the power to either issue an order for the payment of money, or can order your neighbor around, issue an injunction saying do something or stop doing something. So we've combined those two things together. So anyway, that's how the common law kind of grew up. Okay, let's talk about our sources of law. We already looked at our legal heritage, the Roman statutes and the common law. What you'll have today in a modern legal system, in this country at least, is the most basic thing is a constitution. A constitution looks a lot like a statute, but it is what we call the basic law. This is, the law. It's the foundation, it's the bedrock that we build everything else on in our legal system. And so we know we have the United States Constitution, that it sets out all three branches of government, sets up the court system, and the way to make statutes, and the president and all his powers. It also guarantees certain individual liberties through the Bill of Rights. All of those things really sets out the highest legal authority, gives us a framework on which the rest of the legal system is built. States like Missouri or Arkansas or wherever also have constitutions. And they are the basic law of that jurisdiction. The Constitution of Missouri is the basic law of the state of Missouri, on which all other organs of Missouri law are built. The only restriction on the state constitution is it can't conflict with the federal constitution, federal law. So you may remember federalism from your government course. So the United States Constitution can trump the state constitution, but other than that, it's the basic law there that really sets up everything else. We do have, besides the U.S. Constitution itself, sometimes we'll have other law that will have that same type of authority, such as a treaty, which is an agreement that the president agrees to and is ratified by the United States Senate. It's an agreement with another country, and that has the same force of law as the Constitution. So this basic law includes that as well. But for the most part, we're talking about, the familiar Constitution, all the articles, amendments, and so forth. Then we have statutes, which legislatures create statutes at the federal level. That's the United States Congress. In Missouri, we have the General Assembly. Their job is to write statutes. That's really what they do. So they will come up with these laws. They will write them down. Those laws are codified, which means that they're organized by subject, given little numbers, and put in statute books. And so lawyers and citizens or whoever can go read what the statutes are and find out what the law is on a particular thing. Kind of along the lines of a statute is an executive order. The president will do this quite a bit, a lot of the time. And that is an order that chief executive, be it the governor or a president, will issue, and they act like a statute, but they're only in effect as long as that person is in office. So President Obama makes executive orders. Those orders are in effect until he leaves office, and then they go away. So in a way, the president can kind of borrow some of that statute-making authority, sort of. Also, we have the common law, which we already talked about. The courts are busy creating that every day. Every time a case is decided, we'll have another precedent that we need to go. If we ask the question, what is the law on a particular issue, we'll have to look to see if there's any, the Constitution says anything about it. We'll have to see if there are any statutes that say anything about it. We'll also have to see if there have been any prior court decisions that have fleshed out what that means. And a lot of times, a statute will give us kind of the big picture. For instance, one of my favorite examples is in the Constitution. We'll have the Eighth Amendment says no cruel and unusual punishment. Well, what does that mean? The things that they thought were cruel and unusual in 1789 when they wrote that, are very different from what we think is cruel and unusual today. We don't hang horse thieves anymore. So a court will need to tell us what is cruel and unusual. And so we need to go find out what the statutes say, what the Constitution says, and also what the courts have said about it too. We also have another source of law, and that is administrative rules and regulations. We'll have agencies such as, for example, the EPA that go around writing rules. They're not mentioned in the Constitution, interestingly enough, but really where they get that power is from Congress. Congress delegates that power to make rules and regulations to an agency. And what happens is that the Congress is pretty much a big picture thinking type of group of people. So they will say something like, we want clean air. And so they'll pass the Clean Air Act and say, darn it, we want clean air. You can't pollute the air. But of course, the Congress doesn't have time to sit around taking air samples and making sure that the air is actually clean, or figure out how many parts per million of dioxin or something is too many in the air. They don't have time for that stuff. And so what they'll do is they'll create an agency such as the EPA, or give an existing agency power to go and implement that statute. So the EPA has the power to make rules about air pollution. And so under the authority given by Congress and the Clean Air Act, the EPA can go make rules and regulations saying, okay, here is how much pollution is too much. Here's what you have to do about it. And so they'll kind of fill in those blanks and things. And those regulations will have the force of law. If you violate an agency rule, you could be fined. You could be thrown in jail potentially. So it's a serious business, and those rules do have the force of law. Different agencies, their power is restricted by Congress. If an agency does something Congress doesn't like, Congress can come back in and change it, and overrule that agency, because they're really just borrowing that authority from Congress in the first place. So anyway, we have multiple sources of law in our system of government. Well, let's talk now about critical legal thinking. And when you look at the law, trying to understand that system, I remember what it was like my first day of law school. It's a completely different animal than anything you might have been used to. I understand that, so I'm going to give you some tools that I learned when I went through law school that'll kind of help you understand, especially these cases. When you read a case and you're trying to figure out what it's saying, it's kind of written in a foreign language. You'll get used to that. The more cases you read, the easier that will get for you. You'll kind of figure out what some different terms mean as we study that material, and you'll just kind of get used to the way things are phrased. But let's talk about briefing a case. And law students are asked to brief a case, and that really just means break it down into its constituent parts. The first thing that we have when we brief a case is the facts. And that's just talking about, who, what, why, when, what's going on, who is suing who, what are they saying, did they buy a widget and was it defective, whatever the case happens to be about. Just the facts. It just really is that simple. It's just the facts of the case, the people, what they're doing, how they're related to each other, that sort of thing. The second aspect is the issue. That is, what are we asking the court to actually decide? And so if we have a contract case, and the issue might be, was there a breach of contract? It might be that simple. It might be very complicated. It just depends on the case. But it's really, what are we asking the court to determine? And that's the issue of the case. So we'll be looking for that when we read a case. Usually cases will start out with the facts, talk about, the who, what, where, why, all that kind of stuff. Then I'll get into the meat of the matter, saying, okay, this is what we really need to figure out. And that's the issue. And that's really important to be able to spot those issues. Then we have what is called the holding. And that is, how did the court actually decide the case? And in your typical case, you'll start with the facts. It'll talk about, all those, parties and what they're saying happened and that kind of thing. We'll say, okay, well, here's what we're being asked to decide. And then they'll go through a lot of the time and examine if there's any precedent on this. Are there any statutes? Are there any prior cases? And sometimes that's where it gets a little thick when you're trying to read through and figure out what the court is talking about. But at some point, you'll see where the court actually makes its decision. It'll have a holding. And it'll say, the plaintiff wins or the defendant wins, or in this case, my example, Jones breached the contract. And so that's what we're looking for when we're trying to come up with the holding. We need to be able to spot, what the court actually came up with. Then we have the reasoning, which is the why. Okay, we know what the court was trying to decide. We know what the court decided. Then why? In this case, why was there a breach of contract? Why did the court come up with that decision? And that's really important because the reasoning is really what helps us with stare decisis. If we're looking at another case later on, we'll look to see if it has similar facts to this case. We'll look to see if it has a similar issue. Then we'll look to see what the court decided and why. And if the reasoning and the prior decision can apply to our case, that's really helpful. And that means, the court in our case may look at this older case and say, okay, well, this, I need to respect this precedent because, that court had really good reasoning and it was, really on par with what's going on in the case that I'm trying to decide right now. So we need to be able to spot that reasoning, be able to really explain why a court reached the decision that it did. And sometimes that's the hardest part, but we need to be on the lookout for that, be able to spot, what the court is really saying. So, okay, so like I said, legal thinking is different. The first time you try to read through one of these cases and figure out the facts, issue, holding, and reasoning, you may very well be a little frustrated and lots of words you don't understand. I can understand that. That's to be expected. Please don't get discouraged. Hang in there. You will pick this up. We'll be looking at a lot of cases. And, keep in mind, too, you're not in this class to become an attorney. If you were taking, law school classes, you would spend 2 semesters studying property. We're going to spend 1 week studying property. I'm not expecting you to come away as a practicing attorney from this. That's not the point at all. You're just expected to kind of get a familiarity with how our legal system is set up. And really, if you are working in a business, if you're the CEO or whatever, you'll be able to understand the issues when you're talking to your attorney. You can converse in an intelligent manner. But you can also spot problems before they happen, before you have to call your attorney. Once we get through the employment law chapter, you'll know, oops, I shouldn't ask that question when I'm doing an interview anymore. So, we're just kind of giving you a framework that you can be an intelligent business professional and understand the legal environment in which your business operates. So, anyway, please understand that. And I understand this is kind of hard stuff. It's a different way of thinking. But I have confidence in you. You will get it. I hope you think it's kind of entertaining, at least on some level. I certainly don't try to make it any more difficult than it needs to be and try to make it as interesting as I can. Sometimes that succeeds, sometimes it may not. But anyway, stick with it. Hope you have a good semester, and we'll be looking at different aspects of law in more detail next week.